criminal an act done before the passage of the law and which was innocent when done and punishes such an act. 2. Aggravate a crimes or make it greater than it was when committed. 3. Changes the punishment and inflict a greater punishment than the law annexed to the crime when committed. 4. Alter the legal rules of evidence and authorize conviction upon less or different testimony than the law required at the time of the commission of the crime. 5. Assume to regulate civil and remedies only, in effect impose penalty or deprivation of a right for something which when done was lawful. And deprive, this is number 6, and deprive a person accused of a crime some lawful protection to which he has become entitled, such as the protection of a former conviction or acquittal or a proclamation of amnesty. To give a law retroactive application to the prejudice of the accused is to make it an ex post facto law. Let's take the scenario of Batas Pambansa Bilang 195, which was approved on March 16, 1982, amending Section 11 of RT 1319 by increasing from 10 to 15 years the period or prescription of violation of Anti-Graft and Corrupt Practices Act, may not be given retroactive application to the crime which was committed in January 1976, for it would be prejudicial to the accused. To apply BP 195 to the accused would make an effect ex post facto law, for it would alter the situation, his situation to his disadvantage by making criminally for him a crime that had already been extinguished under the law existing when it was committed. So that is People versus Sandigan Bayan et al. The penalty of prisión mayor medium in 8 years and 1 day to 10 years imposed by PD 818 applies only to swindling by means of issuing bouncing check committed on or after October 22, 1985. That increased penalty does not apply to estafa committed on October 16, 1974, because it would make the decree an ex post facto law. Its retroactive application is prohibited by Article 21 and 22 of the Revised Penal Code and Section 12, Article 4. So I repeat, the principle of ex post facto law simply means that the law should not be given retroactive application because it will run counter to the principle on the right of the accused against ex post facto law. Now let's go to the principle of bail of attender. This is the last of the third limitation. A bail of attender is a legislative act which inflicts punishment on an individual without judicial trial. Its essence is the substitution of a legislative act for a judicial determination of guilt. Example, the Congress passed a law which authorized the arrest and imprisonment of the rebels or those rebels that belong to those leftist group, okay, without the benefit of judicial trial. So this is a bail of attender. Their right, okay, as to due process were deprived. They were automatically considered guilty. Okay? A law which makes a crime for a member of the Communist Party to serve as an officer or employee of the labor union is a bail of attender. So, if a person, okay, serve as an officer, then they are automatically considered as a communist. That will be a violation of their right to what we call bail of attender. Now, hand in hand with this right of the accused class, the accused has the limitation, I should say, on the right of the Congress in enacting penal statute is subject to these three limitations as I have discussed, is likewise the constitutional right of the accused, as well as the statutory right of the accused, okay, being charged of a crime. So you will know the provision on the Bill of Rights. There are enumeration in there. So one of the basic that is common and expressly provided there is that all persons shall have the right to speedy disposition of their cases before all judicial and quasi-judicial and administrative body. No person shall be held to answer for a criminal offense without due process of law. Yung number 1 is a speedy trial principle. No, number 2 is the principle of self-incrimination. Yung number 3 is the principle that all persons exert to charge the right to bail. Okay? Number 3 is the right to bail. Okay? Number 4 is the right of the accused to be presumed innocent until proven otherwise. Number 5 is the right of the accused to have a counsel of his own choice, and competent and independent counsel of his own choice. And the right of the accused to have compulsory processes to secure the attendance of the witnesses. Number 6, no person shall be compelled. Okay. Or no person shall be subject to a torture, force, violence, or intimidation. Okay? Or he will be in secret detention places or solitary incommunicado, or the right of the persons against what we call inhuman, okay, detention cell. Okay, number 7 is the right of the accused against excessive fine, nor cruel and degrading imprisonment. Number 8 is the right of the accused against double jeopardy. And number 9, the right of the accused to free access of court, whether it's judicial or quasi-judicial body. Now let's go to the statutory right of the accused under Section 1, Rule 115 of the Rules of Court. Well, number 1 is the right of the accused to be presumed innocent until proven otherwise. Number 2 is the right to be informed the nature and cause of accusation against him. Number 3 is to be present in person and by counsel at every stage of the proceeding from arraignment to promulgation of judgment. Number 4 is the right, okay, to cross-examining the witnesses. Okay. Number 5 is the right against self-incrimination. Number 7 is the right to cross-examine the witnesses. Number 8 is the right to secure compulsory processes or the attendance of the witnesses. Number 8 is the right to speedy trial and partial public trial. Number 9 is the right to appeal. These are the right of the accused or statutory right of the accused. Remember that this constitutional right, as well as the right of the accused, okay, may be waived, except on those rights of the accused pertaining to jurisdiction and the right to be informed of the nature and cause of accusation against him. Because that's very important, class. So next meeting, I'll be discussing the principle of characteristic of criminal law. I repeat, at this stage, please remember this is very vital in studying criminal law. If you know this basic characteristic of criminal law, the principle of generality, the principle of territoriality, and the principle of prospectivity, no matter what question will be asked, you can easily answer it, class, as long as you have studied and understand very well these 3 basic principle, class. So I'll be discussing them on my next video. Please listen to it very well.